Okay, I'd like to call the General Government Committee to order at 3:03, and I apologize for being a bit late. Want to call roll? Or do you?
I can. Supervisor Jurdy, Chair Brown.
Here. We have committee action items, and this is a report to the General Government Committee regarding review of County and Retirement Association actions that increase retirement plan costs. County Council, I believe you are the presenter.
So thank you. So in terms of what was referred to me back when this was originally referred, this was referred to all staff, and it was to look at whether the prior board actions relating to enhancing the county pension plans and indicate whether or not the state mandated procedures were followed in the adoptions of those enhancements. So Janine Nadell had previously worked with Supervisor Smith in trying to gather all of the resolutions. So I had basically a large pile of resolutions. I do not know if they were completely inclusive or not. I've done some research on that, and things that I saw missing tried to find, but it was difficult to determine that. So what I did was I prepared a report that just shows the timeline of the different resolutions. Some of the resolutions in here were from the Board of Retirement itself, and usually that's, you can tell by the different numbering system. But so I looked through everything in terms of what actions the board took. I didn't see anything that looked untoward, or when looking at the actions they took and reviewing the code sections that they were referring to, I don't see anything where they weren't following what was available to them. Again, this was a fairly large process in going through all of it. I certainly couldn't represent that I couldn't have missed something. If something specific was brought to my attention, I'd be glad to look into it. I did put two footnotes in here. One is on page 4, and that's with regard to what the board did, and the requirement in that action was that they had to have had the actuarial study, in front of them to indicate that they were relying on to do that. I was not able to obtain that study, so I can't say, that yes, we did what we were supposed to do, but I can't say that we didn't either. There was one other small footnote, and that's on page 8, footnote 3. And that is when we gave additional service credit. Again, we were supposed to specify some dates that was to occur, and that was not part of the resolution. So whether there was any kind of attachment or anything, I can't, again, say that. So I do believe that there might be pieces missing. I did do, as I said, some further research in terms of just piles we have in our office. But, going back on some of these things, I can say, record keeping is somewhat sketchy. And in terms of my own office, it's difficult sometimes to determine. We don't have a case management system, so it's difficult to determine what actions were taken. But anyway, so that's basically what my findings. And then I did put my conclusion at the end there, and it does appear that state mandated procedures were followed, except for those two footnotes, and again, just don't have the supporting documents to say yes, they were followed, or no, they weren't. And it's my understanding, again, that each year we have an actuarial report prepared which establishes the recommended contribution rates for the following year. But again, I have not reviewed those myself in terms of how those met up with the, with what went on in the county. I will say one further comment, and that is, there's many things where the law provided that you could make additions to the retirement if you had the funds during that time period. And so I saw where we did increases, but I didn't see any specifics, again, with the information I had, where we ever went back and reviewed that and determined, are we still in that financial position? Because those same laws, and there are so many of them constantly changing the retirement system in the state. I don't see where we went back and did any further analysis of, are we in the same position that we were in when we made those raises? And the same things, they're not raises, but when we increased. So I just don't see that we had that analysis throughout, so.
Yeah, and I think it's also important to state that we had a recent court challenge. And in court, and this had to do with the California rule, PEPRA, to begin with, but does challenge the California rule, and that was brought up through a lawsuit with Marin County and Marin County employees. That's going to play into all of this depending how it comes out.
Right, and I did review the ruling on that, and I actually wanted to do some follow-through and speak to the attorneys that handled that issue, but that was a fairly limited ruling.
But it still upheld PEPRA and that state law to reduce benefits to future employees.
Correct.
Supervisor Jurdy.
So I want to take a step back because you've kind of jumped right into it, and I appreciate it. And I also appreciate all the work that you and your office has put into just gathering this information, because it dates back to 1947. So that's quite a bit of documentation. But we'll later get into what you've touched on, which is what's missing still that we don't have, which is supporting documentation, the actuarial studies. But it just a step back from this whole why we're here, and at least for me, it's because, when you think of a public pension plan, you think of the employee putting in $1, the employer putting in $1, and together those $2 grow over time, and so there's some allowance for the person to retire in dignity when they retire after a career of service, and if you ask most employees today, how much are they putting in versus the county, because they see a significant amount on their paycheck going towards the retirement plan, I think most of them would assume the county's putting in the same amount, maybe slightly more, but about the same amount. And very few, I don't think I've met one employee who volunteers and says, oh, I'm putting in $1 and the county's putting in about $4.50. I mean, it's gone way disproportional towards the county, towards the public at this point, that the public's putting in substantially more than they are to the plan, way more than anybody, including, I assume, any county employee ever envisioned when they were negotiating these enhancements over the years. And so what it has led to is, as we all know, it's led to roads not being resurfaced, it's led to county employees seeing their wages reduced and really not being restored to where they were given inflation, since the cutbacks, because so much of the county's discretionary money is being shifted increasingly over to the retirement is a deferred compensation plan. And so that's why I'm interested in, did the county in fact follow every aspect of state law in enhancing the plan over the years? Again, we don't know what would be the outcome if it was found that the county did not follow the procedures, because that leads to legal questions about how would a court rule on rescinding some of that. But I think it's incredibly important that we establish the facts, which is, did the county in fact have actuarial studies? Because my understanding is, as you've referenced, that my understanding is that the county was required to have an actuarial study prior to enhancing the plan each time they enhanced the plan. I don't know when that rule became effective. I think it's a state law. I don't know if it was effective in the 80s and the 60s, or at some point in the past it became, my understanding, a requirement. So as of that point, did the county always do that? And if the county did not, then, everybody should know whether the county did it or not. And if it didn't follow the rules properly, then we still need to wrestle with what do we do with that information. So we've got a good starting point here of information, but I don't feel like we have all the information we need to really get into those then legal questions about what do you do with that information. So those are some of my thoughts, just, coming to why I wanted this on the agenda in the first place, and at some point going back to the full board.
Well, what I have found since I've been sitting as a county supervisor, many times you go back and you can't find the records. It's a paper chase. It's electronic today and a paper chase of yesterday. And many times I have been really disappointed in complete files. Not that it was anyone's fault, but that's the reality of it. And I can look at it, even sitting as a LAFCO commissioner, that how processes, paper files, paper trails, and I think it's really difficult. And I don't know how much that would cost to do what you're proposing. We all know as supervisors, any more than 4 hours of a time has to be approved by the full board. Yes, we'd have to put money into it, and that would be a question of the full board again, and being able to at least have a majority backing that.
Okay. And I do want to add, and I want to add just in this historical context, because, I've been only looking at this really relatively deeply in the last 3.5 years, but, or 4 years, but I think just it's important for the audience who may be watching this on television, not necessarily the ones in the room, to know is that the county and the retirement board have made some incremental changes as
Yes.
allowed by state law,
Exactly.
which have certainly, I'm certain they have, if nothing else, they've slowed the growth of the costs of the pension plan, but I'm not convinced that they will stop the growth in the pension costs. And so that's why I'm concerned that more needs to be done.
Just a further comment, the board did authorize 80 hours to work on this project of staff time. So I can say just, my staff just organizing this, and then I had a legal intern, very bright, free, but we went substantially, just in my own office, substantially over 80 hours. Again, a lot of that was a free cost, so we did actually a lot less if you include that. But just putting this information together, reviewing the code sections, it was a substantial project. So
So you're confirming it needs to go back to the board?
yes. And the other thing is, there's the one thing I learned, and I have learned a lot of things about government very quickly, but the retirement law is very, very complex because there's so many different pieces. So I would have to say, ultimately, if there's a decision to be made in terms of a legal opinion, I would want to bring in some outside help on that. I don't feel a year or two I would even really, let's just say in the next 6 months, I'm not going to be a retirement expert.
Well, and I think the court case, going back to that, it was over pension spiking. And I think they'll probably go forward to the Supreme Court, which may overturn it, or give us more of a definition of what they mean and what we can do and can't do as we move into the future. So it was all very interesting to me, and be interesting to see how we go forward. And if you read the briefs, City of Stockton chose not to go forward with the legal ruling that they received. But I expect this with Marin County to go forward, so there'll be, I'm sure, more discussion. Do you have any more, Supervisor Jurdy, that you want to discuss with council, or shall we go to public
let's go to the
comment?
public,
Okay, we'd like to go to public comment. Anyone that would like to comment, please come forward. State your name for the record. I know you, but you have to state your name anyway.
Yeah, I'm Ted Stevens. I'm speaking here as a finance guy. I've been in practice for a little over, I guess about 35 years. I have a master's in tax, a master's in finance. I kind of do this finance stuff for a living. I manage a lot of qualified plans. I've been on the pension board for 6 years. I've studied it for about 2 years before that. I am very, very concerned about our plan. It is not getting better, it's getting worse. I hear in reports, I hear from our administrator that everything's okay, we're doing the right thing. Don't believe it. And the reason you shouldn't believe it is the actuaries have never told us the truth before. We did a 1996 bond flotation. Fool me once, shame on you. We did a 2002 or 2003 bond flotation to firm up the plan again to make it whole. We lost all that money too. We're deeper in debt than ever. Fool me twice from the 2002, 2003. We're deep in debt again. Shame on us. Fool me 3 times. It's not getting better. The last 2 years we have absolutely no rate of return. If you look at it as a percent of salary, it's payroll of the county, it's out of this world. Supervisor Jurdy said that we pay about 4.5 times, it's closer to 5 times is what we pay. So for every dollar the employee puts in, we put in about almost $5. Still not a single new dollar ever goes in the plan. A single dollar from the employee, a single dollar from the county. It's a sad situation. If we had a fully funded plan, you can make an argument, well, that's the way it's supposed to be because we have a mature population. The problem is we're deeply underfunded. We're about 70% funded. As I said, last 2 years after administration expense and investment expense, no rate of return at all. Our plan is designed now to sell, even in a good year, sell a certain part of the earnings to make benefit payroll and administration payroll. It's getting worse. Look at it by any measure, it's getting worse. If you recast it to what it should be, if you take a look at what our investment advisor says our go-forward 10-year rate is, or look in the rear view mirror what our 10-year rate is or 17-year rate of return, we're about 100 to 125 basis points too high on our target rate. If you recast it, we're way down, we're way below 70. We're probably, if you take the pension obligation bonds, we're 45 to 50% funded if you really look at this thing accurately. This is a mess, and it's not going to get better by doing the same old thing we did when we did the 96 bond flotation, the later bond flotation, and everybody says the actuaries we have to believe our professionals. Don't listen to your professionals anymore. It's been a disaster and it's getting worse. We need to do something about this. We need to have some kind of intervention. If we go, I'm very worried about the ability to pay benefits. If we keep going this way, it's going to be too late to save the benefits. That's what my financial mind's telling me. Thank you.
Thank you, Ted.
John Dickerson. I know this must have been really hard to put together. I can imagine the condition of the files back there going back to the 40s. And I also know that the county employment retirement law is an incredibly complicated creature. It's just a horribly written law in many ways. And it's very hard to go through it and follow exactly what different parts of that law are trying to tell you. Last year, the Marin County grand jury produced a report following up on a similar report by the Sonoma County grand jury about were the legal processes that are established in law followed when those two counties increased enhanced pension benefits in the 2002 to 2005 period. And both of those county grand juries, as well as the Sutter County grand jury, concluded they did not follow those procedures.
Sutter or Sonoma?
Sutter County.
Okay.
And the way Marin County's grand jury expressed it, the government code contains specific requirements that must be met before local governments can increase the pension benefits for their employees. At the time the consideration of the enhancement at issue, what they're saying is that at the time that Marin did those increases, which was the same time as Mendocino was doing it, the employers were required to provide notice to the public of any potential pension increases on the board of supervisors meeting agenda, 2-week notice, obtain an actual evaluation of the future cost of the enhancement, and I believe it's supposed to be an evaluation by an independent actuary, not the pension funds actuary. I believe that's true. Present that actuarial analysis at a public meeting 2 weeks before approving the increase, and explain the impact of the proposed increases on the pension's financial health and funding. Marin County didn't do it, Sonoma County didn't do it. If they didn't do it, I can't imagine this county followed those rules. I just can't imagine it. And I think we should see the notices that are pursuant to these requirements. We should see the independent actuarial valuations, and we should see the minutes of the meetings where those benefits were passed. Were they publicly noticed, or were they buried in a consent calendar? Those kinds of questions. I've got 18 seconds left. When the title of this was to review actions by the Board of Supervisors and the Retirement Board, and what is here is a list of resolutions is what I'm seeing. Well, actions may be limited to a narrow definition of that, or you could say things that were done, actions, whether or not it was directly related to a resolution. One thing we know now with absolute certainty, because the retirement board authorized retirement officials to sign an agreement with the Internal Revenue Service, a compliance agreement, where they specifically admitted to violating 2 laws. One law was the County Employment and Retirement Law that said that all county contributions for pensions must go into the pension fund. $6.1 million, according to the Retirement Association's own calculations, were diverted from the county's contributions to pay retiree health care benefits. There's other aspects of law that were clearly violated. The county treasurer at the time did those diversions. A county official did those diversions. And it is now an admitted fact. And there are so many of those kinds of actions that I think should be included in the purview of the word actions. What did the county and the retirement board do that created these unfunded pensions? I think most of the debt was not created so much by what the pension benefit is supposed to be. It was created by the failure, in many cases I believe purposeful failure, to properly fund them. And that's where I think the problem came from, and I think that's where the problem still remains, is the failure to be honest and accurate about what it really takes to fund the pension promises that the county's made.
Thank you, John. Anyone else? Seeing no one, come back to the board.
Well, it looks to me like we do have a good starting point for information. I do, again, appreciate what we have. What we have is a summary of actions and the dates of those actions. It would be, I think, helpful if those items were on the county website in some way with links to those documents, so that we, the board, or anybody else could actually then go read that document, and we have a helpful summary here and dates. But and this is on the web, but we don't have then a hot link that, as far as I would know, that takes you back to these resolutions. I wasn't able to find it on the county website if it is there. So I think that's one thing. And two, I think I would like us to recommend that the board authorize additional staff time to get more research. Were actuarial studies conducted for these, in support of these actions, or not? I mean, what we have now is we have the answer is there's not a record of it in this file, but that may or may not mean there was an actuarial study.
So go ahead.
Sorry, so this is sort of the book we put together. There's of the things that were gathered. There's many things in here that I didn't think related to this, so I didn't include it in the list. We do have that on a flash drive, but again, there's some pieces in there. Some things are resolutions. Unfortunately, in terms of the record, I don't have the minutes that go with that. I have maybe a couple minutes here and there, but I don't, it's very difficult to determine these are the things I believe were passed, so I don't have the follow-up. And then in terms of all the actuarial studies, certainly don't have that. It would take somebody besides a legal opinion to look at those and say, in that time period, was that a basis? Did what we do match what the actuarial table tells us? So just a note.
Sure, and again, I go back to the fact that you've stated that you went well over the 80 hours and probably the 3 or 4 more hours that's entitled to each supervisor to have on any one subject. So I'm going to recommend that, does Alan have something? Oh, okay, I'm sorry. Mr.
Well, I don't need to interrupt now if you wanted to continue your thought, but I guess the point that I think would be helpful for staff to have some clarification on, and maybe it's more appropriate to get this from the full board, but I think some clarity on the purpose of this exercise would be helpful. I mean, I think we all understand that there's a large liability there that needs to be resolved over time. And, your board has had a number of conversations about what to do about that. And, there is a long-term plan in place to resolve that issue. However, I guess I'm struggling to see how a significant amount of staff time into past actions would impact that exercise. So I don't know what you may have on that, but I think in looking at that may help. I mean, I'm concerned about going back and looking at each of those actions over time and the magnitude of that work, and if we could focus that in some way, I guess I'm not sure exactly what specifically we're looking for.
Well, and I can let Supervisor Jurdy explain that, but to finish my statement, I was basically headed down the same track, that it does have to go back to the full board, and a history purpose should be contained within an agenda summary to be presented to them along with what general government has received. Should probably be included on that agenda item. But I'll let Supervisor Jurdy respond.
Well, so I understand what you're saying about where's the focus of the research, and perhaps it's not so fruitful to go back to some of the earlier actions in the 50s and the 60s, because honestly they've been superseded since then by later actions of later boards back in the 80s and the 90s and the 2000s. So I think the focus of the research could probably start with the 2000s and the 1990s, because those would have been the richest of the enhancements. So if some of those richer enhancements were found to not have followed state law, that's actually more important than finding out that a 1965 enhancement, which has again probably been superseded 5 times since then, did or did not follow law. So I would say start with the most recent. I mean, there hasn't been an enhancement, I think, to the plan since before you were supervisor. In the more recent era, that there's been either nothing added or things taken away from new hires. But yeah, so 2000s, well, there's certainly not much in the recent era. So I think the focusing on the more recent, like the early 2000s, that's really mid 2000s, that's really when the rich enhancements started to kick in. And I would quibble a bit with Alan, you said that there is a plan to pay off the debt. I don't think anybody believes that. I mean, there are payments and there's a schedule, but that schedule assumes things that aren't true. I mean, the plan is not 100% funded right now, so that means there's no earnings, even when we have a good year and earn 7%. But there's no earning on the 200+ million that's not in the fund, So,
Well, yeah, we could quibble about whether we agree with actuarial assumptions, but the actuarial study, in and of itself, is a plan for paying that debt off over time, in my opinion.
but I just don't think if we stay with the track we're on, in spite of the reforms that have been made in recent years, the debt will, in my opinion, will continue to grow, and it will not go down.
So, at risk of going into territory maybe I shouldn't be going into right now, I guess, in listening to some of the comments from the public, back to the purpose of researching potential actions that were not done appropriately. If you follow that through and we paint a picture where there was some action taken that was not done according to the law, how does that solve our current problem?
It may or may not, but first of all, disclosure is always good. You can never go wrong with public disclosure. Two, if it turns out that an enhancement was made to the plan that was not legally supported, then we need to access specialist attorneys who can explain what are our options. At this point, none of us in this room really know what our options are. If it turns out we have the ability to withdraw that benefit, even if it's only prospective, like for today's employee, for their last 5 years of service or for their last 20 years of service, I personally would vote for it because the county cannot afford the plan. The plan is too rich. It is too rich to have a retirement plan that pays someone more in retirement between the plan and Social Security than they earn in their last day of service. It's just too expensive.
Okay, well, I think
So-
that provides the clarity I was asking for. I just think that's an
my
important
opinion.
conversation for the full board if we're to dedicate a significant amount of time to that research. So.
Well, as chair of General Government Committee, I'm going to look towards Supervisor Jurdy to work on that agenda summary and be able to summarize just exactly what you've stated here today and get it prepared for an upcoming Board of Supervisors meeting, because we do have our rules about our own costs and overruns, and we do have to keep within budget on those. And to do anything further, it does have to go back before the full board, and it should be an item that you help prepare and help explain before the full board,
Okay. Yeah.
okay, along with purpose. That's okay. Now, I do want to ask about one other document that doesn't have anything to do with this topic, so it's just other business, but it does have to do with the retirement board. And on August 23rd, James Wilbanks, thank you, sir, for writing this letter. The board asked the question about the voting authority in the absence of a trustee appointed by a board of supervisor if that trustee is absent. It's my understanding, and maybe Supervisor Jurdy can explain it further, that other members, other trustees on the retirement board do have alternates, but Board of Supervisors appointees do not. So I don't know how you want to come back.
Well, so I supported this on the retirement board, and the retirement board, I believe, was unanimous on this in requesting that, since the county does have a legislative platform that you've worked on for several years, that we add this to our legislative platform for this coming year to request an amendment to the law
Okay.
to allow our appointees to have, let's say, a floating alternate.
Alternate, one floating.
Yeah.
Okay, so you want that to be on the legislative platform because we're going to have to change the law, correct?
We can't do it unless the law is changed.
Exactly. Okay. So that will be a report to the full board and a recommendation to whomever's going to do the legislative platform. Alan, I'm sorry, I didn't mean to interrupt you. The legislative platform has been done by an ad hoc committee in previous years. Is that going to be part of the responsibility now that we're doing standing committees again of the General Government Committee?
I believe so, but I'm not sure on that. I have to follow up with you. Do you know, Dan?
I thought we referred, when we collapsed the ad hoc, that I thought we referred it to this General Government Committee. So my assumption was that Sarah would be coming to our General Government Committee in maybe October.
Okay, I just don't want to
That sounds right to me, but I'd have to confirm.
I just don't want this to get lost. And I want to make sure it's acted on.
Okay.
So maybe it can go into our actions and recommendations.
Sure. Yeah.
Okay. And we will have to do some research on this, and I'm sure Sarah will help with it, so we'll have something, and really the legislative platform work should start in November.
Yeah, I believe Sarah's already been working on preparing for that, but.
Has she?
Yeah.
Okay.
Yeah.
All righty.
Can I speak to that?
Yes, sir, please come forward. You're now under public expression.
Thank you. Ted Stevens, Retirement Board, independent financial guy. Yeah, so the reason that is important is right now, the board is made up of 2/3 people that have a vested interest in the plan and 1/3 that aren't. There are 3 people that are appointed by the Board of Supervisors. The retired member has an alternate. The public safety has ability to have an alternate. So there are already 2 alternatives for the 2/3. There's not even, I think most of us who are going to recast this, we'd take a look at least having it be 50-50 independent people rather than have foxes always counting the chickens. But it's even worse now because then there's been legislation by this guy Cooper to even have it, I believe, worse. But the independent people should at least have representation. If one of them is not there, that at least will hold the 2/3, 1/3. So at least we have 1/3 represented that don't have a vested interest. So that's why it's important. But what I'd really like to speak to is why it's important to go through this exercise that we're looking at. Is a fiduciary on that board, I'm very concerned about the ability to pay benefits. As a fiduciary, if I'm paying benefits today that aren't authorized, and in the back of my mind, the whole time I'm thinking, how are we going to make this plan whole enough to make sure we can pay the benefits to the people that are putting their contributions towards it, as the county is, they're 4.5 to 5 times that, without a single dollar ever hitting the plan. That is like mind-blowing in my mind. There's not a single dollar. Your dollar doesn't go in the plan. The dollars that the county puts towards you don't go in the plan. If I'm a fiduciary and I'm paying benefits that aren't authorized, it's darn important we find that out, because there's not enough money, even with this huge amount we're paying now, to make this system go, in my opinion. So if we do have illegitimate benefits, we should discuss what we do about those. And we certainly wouldn't just keep paying them blindly. Thank you.
If I could just
Yes.
add on, so Sarah would be, it would work with where she's at now to come back in October, and then depending on the level of changes or additions your committee may have, could bring the recommendation to the full board in either November or December and be prepared for the new year. So.
Sounds good, and I do want to ask Mr. Stevens a question. You talked about legislation currently. You said Cooper?
Yeah, Cooper has a bill, and I think.
Can you speak to the microphone?
Could you come up and,
Yeah, this, yeah, unfortunately, all this stuff is mind-numbing. If you read the serial, it's mind-numbing. But if I remember in Cooper, Cooper has a bill, and I think it actually adds more alternates for those with a vested interest, the two-thirds in the plan, when we reviewed that bill, or when I've reviewed it. But I believe there are other 37 Act counties that do have this. I think if I remember correctly, there are 2 of them that have it for those that are independent, the ones that are placed by the Board of Supervisors. It seems it would make sense in this county to do it. I think in a perfect world, what we'd like to do is go to the legislative process and have 50-50. So we have part people that are covered under the plan and part that are independent citizens of the county. That probably doesn't fit. That's too big to bite off on this. But since there is, I believe, precedent from other counties having this alternate for the independently Board of Supervisors trustees, it makes sense to ask for our county to have that too.
sure, and Mr. Cooper, is he a Senate or Assembly?
Is he Assemblyman or Senate? Cooper, he's out of LA, and,
I think
pardon?
I think Dr. Wilbanks can answer that question because
Oh.
he has attended the statewide conference from the association.
Okay, great.
James Wilbanks, Retirement Association. The bill in question is actually AB 2376, which was a technical correction bill which was sponsored by the Assembly Committee on Public Retirement. It's not the Cooper bill, which is AB 1853 that Mr. Stevens is referencing. So it's AB 2376, a technical correction bill sponsored by the committee, the Assembly Committee. It did a number of technical corrections. It also changed the language on the voting authority of the retiree alternate that is currently in statute, that allows that alternate to vote if the retiree member is present, but 2 of the elected members are absent. So it's a very specific situation in which the retiree alternate could vote in place of other elected members. So
For clarification purposes, when you're referring to elected members, I believe you're referring to the 2 active the active employees who are members of the association. They've been elected by the employees. And
it's
so,
the 3, 2 general and 1 public safety.
and I believe they're the electeds that you're referring to, not an
That's
elected
correct.
supervisor or
Yes.
an elected treasurer.
Yes, that's correct. The elected members of the plan who are elected by other members to the Board of Retirement. Yes, that's correct. Does that
Yeah,
make
I think
sense?
that it does. I'm just trying to find maybe something to follow here, do a little bit of research.
AB 2376
Okay, got
is
that.
the bill. It was sponsored by the committee. It had a number of technical corrections. Some for LA counties, 1 I think for Ventura County was a request. This specific item was a request from CRCEA, I think it was, the California County Employees Association, something, whatever that acronym is. There was a request from SACRS, the statewide county retirement systems, authorizing electronic signatures for enrollments, so we don't have to get signatures on enrollment cards. So there were a number of things that the Committee on Public Retirement in the Assembly saw as non-controversial, rolled them all up together into one bill, and that was sponsored by that committee, not a specific representative or assembly person.
Just trying to get a grasp how to go forward here and what to look at and see what's passed and what hasn't, which is still going through.
So AB 2376 has been enacted. It has been signed by the
Okay.
governor. And the recommendation in the letter there is that Mendocino County, we recommend the Board of Supervisors pursue legislation to add an alternative trustee to the Board of Retirement who can vote in place of Board of Retirement appointees, of which there are 4, one of which may be a supervisor, and currently is Supervisor Jurdy.
Correct.
The other 4 are independent, have no affiliation with the Retirement Association. So, and there are, I believe, Mr. Stevens is correct, there are 2 or some number of other counties that have similar alternates.
Okay, and maybe I need to get in contact with those 2 counties.
Yep. And we'd be happy to help Sarah or other staff
All
in
right.
any way necessary.
Okay, that sounds wonderful. Appreciate it very much. Thank
you.
you.
Okay, so I'll work on an agenda summary for, it's not going to be Tuesday's meeting for sure. The deadline, I think, is maybe passing very quickly for the following week's meeting, but it looks like the first meeting in October would be when we would get this on the, I would think.
And I believe that's October 3rd?
October 4th, yeah.
4th, okay.
First
And then I
Tuesday.
think there's one, the second Tuesday, if I just look. So it'll be one of the October meetings.
I think the target will be October 4th, yeah.
So we have the 4th and we have the 18th? All right. So you're going to work on it?
Yeah.
All righty. And then maybe we can do some other research about the 37 Act, 2 counties that have had the changes. And we could talk about moving this onto our legislative platform and get it underway as quickly as possible. Because I think February is a deadline. Maybe we should take separate action than just putting it on our ledge platform, having it on there, but maybe we should have the start up much sooner. What do you think of working on this?
Well, either or both of us could speak with our legislative representatives and see if this is something that they'd be interested in picking up this year,
Okay?
knowing that it's likely to be in our legislative platform, as a heads up.
Right.
So-
I think that's important. Do you want to take that
Sure,
on?
I'll do that, yeah.
Okay. So we have direction. I'd like to call for any more public expression. Anyone that would like to speak, please come forward.
Stan Anderson, City of Fort Bragg. I live there, I don't work for them. Okay, Ms. Elliott had a question, how far do we go back or something? Actually, there was a number of provisions in the California Government Code that took effect in 2001. And I would think that seeing most of the action, as Supervisor Jurdy mentioned, took place, since 2000. That might be a good place because it's very specific as to what the process is supposed to be, and so that would cut out 30 years or more of activity to go back. And in fact, actually, I would suspect that a lot of that is probably in electronic form already. I think it's already digitized. I mean, for instance, the fact that this legislation specifies that any changes to the retirement plan cannot be done on the consent calendar. That should be fairly easy to find, by doing a search electronically. So I'm fairly certain that we can make at least some of those provisions available. I got some right here, for example, that she could look at and use as a guide. And then, might help her research. If she doesn't already have it, she probably already has it. But I think she doesn't really need to go back. I mean, and it would be in an area that's, relatively close in. And so it should facilitate the ease.
And not to respond for Supervisor Jurdy, who's going to be working on this agenda item, I think that is what he stated, that rather than going that far back, and if you do have information that you'd like to share with County Council and Supervisor Jurdy,
If you
that
could
would
give
be
a copy to
great.
Nicole, the clerk. Thank you.
Thank you very much, appreciate it.
Thank you, sir. Anyone else? Okay. County Council.
So I think one other thing that I'm just going to do, just to do a little bit follow-up on this, is to at least look at the other grand jury reports that were mentioned. I hadn't heard of those. I heard earlier today, actually, about that. So I thought I'd take a look at that and see where they saw the problems and at least relook at those areas in our own, so.
No, I think that's very good. Thank you. Anything else?
Alan, you're shaking your head, but your yellow pen's up.
That's okay. Yes,
The next meeting of the General Government Committee is scheduled for October 17th.
October 17th? Okay. The day before the 18th, which is a Board of Soups meeting. All righty.
Well, for clarification, though, I think it looks like you're okay, though, with my working on an agenda summary prior to our next general government committee.
Oh, absolutely.
yeah, okay.
Yeah, it needs to,
Go to the board.
yeah,
Okay.
and to get it done and go forward. I don't like dust to settle under our feet, because then that way it gets lost in time.
Thanks.
Okay, all right. We're going to adjourn the meeting. Thank all of you for being here. Appreciate your participation.